Morning everyone. Well, you can see that I'm not in the fields this morning. Neither am I at home. So there's that. I'm in an undisclosed location, brought to you this morning by Pepsi Max. If you remember back to the 10th of January, Bryan Kohberger's attorney, Ann Taylor, who's had her own dramas this week, requested a bunch of stuff for discovery, which they're entitled to. The discovery, they're entitled to what the prosecution have. They can then use that to build their own case or to debunk certain things that the prosecution is claiming. So they wanted all the statements, everything that had ever been produced in conversation with Bryan Kohberger, the same for any co-defendant, defendant's prior record, all the documents and everything. They wanted everything. Tests and examinations if they were done, state witnesses, names, addresses, phone numbers. They wanted a list of expert witnesses. They wanted police reports, everything, even field notes. They wanted all digital media recordings, electronic surveillance, identification. So was he identified in a lineup, any inducements, just everything, subpoenas, search warrants, you name it, they wanted it. Well, the state yesterday issued a response. So it is that we are going to turn to today. We're going to go through it all, but to address one specific point, because this document didn't dispel the possibility that there is a co-defendant, i.e. that Bryan Kohberger did not work alone. They could have dispelled it, but they've chosen not to, which I find really interesting. So we're going to read it through. Now, co-defendant thing comes up at point 2, so I'm going to skip over that and do that at the end. So the state has complied and will continue to comply with such requests by providing the following. So it doesn't mean to say that they have supplied it all at this moment in time. Some of it will still be ongoing, some of it will be pending, some of it just won't be ready. All right. But we'll see at the end just how much has been provided to the defence already. And it's a lot. So people who are saying they don't have very much, you know, the probable cause affidavit, yes, it's big for a probable cause affidavit, but they don't have very much. Well, this is just the tip of the iceberg of the thousands and thousands of pages and files that have accrued already in this case. So, this is what they are promising or have supplied. Any relevant written or recorded statements made by the defendant or copies within the possession, custody or control of the state, the existence of which is known, is available to the prosecuting attorney by exercise of due diligence, and also the substance of any relevant oral statements made by the defendant, whether before or after arrest, to a peace officer, prosecuting attorney, or the prosecuting attorney's agent, have been or will be disclosed or otherwise made available. So probably they've got everything to the defence that they've got to date. And then it says, see Exhibit A, which is terribly exciting. Exhibit A must be an amazing document to go through. Huge, but amazing. Everything refers us to Exhibit A, which is the last page, but we'll get there. So I'm going to come back to number 2 because that's relating to co-defendants. So defendant's prior criminal record, if any, or will be disclosed or otherwise made available. He doesn't have one, he has an infraction, but I can't find a criminal record for him, he doesn't seem to have one. Okay, number 4, any books, papers, documents, photographs, tangible objects, buildings or places or copies or portions thereof, which are in possession, custody or control of the prosecuting attorney and which are material to the preparation of the defence or intended for use by the prosecutor as evidence at trial or obtained from or belonging to the defendant have been or will be disclosed or otherwise made available. In addition, deputies and officers from the Latah County Sheriff's Office, Idaho State Police, Moscow Police Department, Idaho Fish and Game, and other law enforcement agencies may record their law enforcement contacts via an audio recorder or audio-video recorder. Any audio and video recordings related to this matter are available for review and duplication on request, subject to this provision here, pursuant to said subsection, and except as otherwise specified therein, any such digital media is unredacted, may contain protected information, and thus distribution is restricted by this provision here. Alright, so what that means is that they have some of them, so available for duplications on request, as long as they are under this provision here. Some things may be restricted. Some of it won't be in the actual hands of the prosecutors. You know, they'll have been able to review some of that documentation, but the defence will have that opportunity to review it. Doesn't necessarily mean they'll get it in actual format to them. Any results or reports of physical or mental examinations and scientific tests or experiments made in connection to this particular case, or copies thereof within the possession, custody or control of the prosecuting attorney, the existence of which is known or available to the prosecuting attorney by exercise of due diligence, have been or will be disclosed or otherwise made available. So yeah, they're going to send that if they've not done so already. Written list of names and addresses of all persons having knowledge or relevant facts may be called by the state as witnesses at trial, have been or will be provided separately in accordance with this little provision here. Any record of prior felony convictions of any such persons, which is within the knowledge of the prosecuting attorney, and all statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents, or any official involved in investigatory process of the case, have been or will be disclosed or otherwise made available. Consistent with Ramirez versus State, 119 Idaho 1037, and Idaho Public Safety and Security Information System, restrictions on dissemination of criminal history information, the state generally does not seek NCIC reports or Spillman reports of witnesses. Additionally, the state may call as witnesses anyone otherwise identified or referred to in reports, statements or other documents referred to in this response. Okay, so be things they don't get. So if they don't get it, they can't supply it. Any written statement or document of any testimony that the state intends to introduce pursuant to Rule 702, 703 or 705 of the Idaho Rules of Evidence at trial or hearing have been or will be disclosed or otherwise made available. This response does not necessarily include disclosure of expert witnesses, their opinion, the facts and data for those opinions, or the witnesses' qualifications, intended only to rebut evidence or theories that have not been disclosed under this rule prior to trial. So what was number 7? Alright, provide a written summary or report of any testimony that they intend, blah blah blah. The summary provided must describe the witness's opinions, facts and data for those opinions and the witness's qualifications. The underlying facts or data that form the basis of any expert testimony pursuant to Idaho Rule of Evidence 705, disclosure of expert opinions regarding mental health shall also comply with this requirement. This response does not necessarily include disclosure of expert witnesses, their opinions. So they're not going to give that if it's intended only to rebut evidence or theories that have been disclosed under this rule. Okay. Reports or memoranda in possession of the prosecuting attorney by police officers or investigators, they'll go. All materials or information within the prosecutor's possession or control which tends to negate the guilt of the accused as to the offence charged, or which would tend to reduce the punishment, therefore, will be disclosed or otherwise made available. In addition, with regard to material or information, will be used or interpreted the state requests that the defendant inform the state in writing of the defence which will be asserted in this case. So counsel for the state can determine if any additional material or information may be material to the defence. Okay, so they want the defence. They want stuff back from the defence. They want the defence to inform the state in writing of the defence which will be asserted in this case. So, you know, I'll scratch your back, you scratch mine. Stuff falling off this tree above my head. To the extent that information exists regarding an informant who is not going to be produced as a witness, including recordings or written statements of an informant, or that identify an informant, such information is not subject to disclosure, and the state asserts informant privilege. So if they have informants, they're not going to disclose that they've got informants because they don't need to. The state objects to requests by the defendant for anything not otherwise addressed above on the grounds that such requests are outside the scope of. Good for you. You tell them. You tell them they're just being cheeky. They either don't know the law or they're just being cheeky. I think they're just being cheeky. Wherever this response indicates that certain evidence or materials have been or will be disclosed otherwise made available, such indication should not be construed as confirmation that such evidence or material exists, but simply as an indication that if such evidence or material exists, they have been or will be disclosed or made available to the defendant. Okay, any items which are listed in Exhibit A but are not specifically provided or which are referred to in documents which are listed in Exhibit A are available for inspection upon appointment with the prosecuting attorney's office. Additionally, all property forms, chain of custody documents and similar items are likewise available for inspections on appointment. Okay. So all of those items, whatever they are, will be available on inspection from their office, will be available to review, you know, as and when they become available. But they're not going to give it, not going to give them, because maybe, you know, it's physical evidence that maybe. Alright, so we've got to go back to number 2, but we've got to bear this in mind. Where certain evidence or materials have been or will be disclosed or otherwise made available, such indication should not be construed as confirmation that such evidence or material exists. Simply an indication that if such evidence or material exists, they will be disclosed. So that takes us back to number 2, where I find the wording interesting regarding a co-defendant. So it says, any written or recorded statements of a co-defendant and the substance of any relevant oral statement made by a co-defendant, whether before or after arrest in response to interrogation by any person known by the co-defendant to be a peace officer or agent of the prosecuting attorney, have been or will be disclosed otherwise made available. So it doesn't mean to say there is one. But if one becomes available, if they find one, if Bryan Kohberger discloses while he's sitting in his jail cell that there was a co-defendant, that there was an accomplice, a getaway driver even, then that would be new news. And they'd have to obviously interview that person. And then if that person is arrested, if there's probable cause to arrest that person, then they will disclose, because it will have been made available. But it doesn't mean to say, this document doesn't mean to say that there's a co-defendant right now sitting in a jail somewhere. Is it possible that they've arrested someone and kept it all under wraps, everything under wraps? Yeah, but why would they? What would the purpose of that be? Might they have someone in their sights who they're watching? Yeah, they may well. There may well be further arrests. However, in my opinion, in my humble opinion, I think Bryan Kohberger acted alone. I reckon I'm 90% sure that he acted alone. But anything's possible. Anything's possible. So, if Bryan Kohberger discloses information about a co-defendant, or someone else does, you know, like an informant, somebody comes forward, or somebody makes a confession, and that's deemed credible, then that will become a co-defendant of Bryan Kohberger. Therefore, they'll make available at a future time, when they become available, all of that information as requested. So that's what I think it means. Excuse me, Dougie. Excuse me, Dougie. What are you doing? This isn't Cassie. Looks like him, very similar markings. No relation as far as I know. Well, no close relation. I mean, all Springer Spaniels are going to be related, but... Dougie, you can't sit there. Dougie, Dougie, Dougie. Look, you're knocking everything off. Dougie, please. Dougie, please. Dougie. Dougie. I can't work like that, Dougie. I can't work like that. Alright then, let's move. Dougie! 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 Oh, Noodle's here now. Noodle! Oh my god. Oh. See, the thing is, my dogs understand filming. Dougie doesn't have experience of it, do you, Dougie? So, yeah. Alright. Look. Alright, we're going to try and do this. Right. Final thing. Exhibit A. Here is Exhibit A. Police reports and documents covered by ICR 16, which are in the possession of the state, have been disclosed to counsel for the defendant as of January 23rd, 2023. So we've got almost 1,000 pages and a shed load of photos and one video. 1,865 photos. 1,000 pages. That's just for starters. That's just for starters. Alright guys, let me know what you think in the comments below. I've been Michelle, I hope you're well. And it's goodbye from Mr. Doug. Mr. Doug.